Tuesday, February 6th. It's our late 3:30 afternoon meeting. We're starting a little late because we've been going over a little bit with our previous testimony, but we have with us here our legislative counsel, Katie McLinn, to walk us through what is current statute in Title 28, which is DOC, that pertains to healthcare, delivery of healthcare services in our correctional facilities. So Katie's done a yeoman's job. There is a doc on our committee page, well, as there's a hard copy here, but Katie's done a terrific job in summarizing all the different sections of Title 28 that deal with healthcare services in our correctional facilities. So Katie, welcome.
Thank you.
And if you could identify yourself for the record.
Sure. Katie McLinn, Office of Legislative Counsel. Thank you. So I don't spend a lot of time in this committee. I generally staff healthcare and human services issues, so I spend some time with your colleagues upstairs. I have put together a document that summarizes the provisions in Title 28 that deal with healthcare treatment for the correctional population. It's broken into three sections, kind of three main categories, and I'm actually going to skip the first category and come back to it because I think it will make more sense after we sort of go through the other categories. So this language that we're skipping is about how we would transfer custody. Somebody who's in the custody of the Commissioner of Corrections, they need mental health care. How do they get transferred to be under the commitment of the Commissioner of Mental Health? So we'll come back to that. But for the moment, we'll start on provisions of healthcare, Section 801, and this pertains to medical care of inmates. So our first section is that DOC is required to provide healthcare for inmates in accordance with the prevailing medical standards. If receiving this standard of care requires an inmate to be taken out of the facility, DOC has to provide safeguards, if necessary, for the custody of the person to be confined while in the medical facility. And then subsection B moves into what happens when a person is first coming into the correctional facility. So once an inmate is admitted to the facility for a minimum of 14 consecutive days, the inmate must be given a physical assessment unless there are certain extenuating circumstances for not doing so. More rapidly than that, an inmate is screened for a substance use disorder within 24 hours of admission at the correctional facility. And as part of that initial and ongoing screening and assessment process, there's a specific screening for opioid use disorder. If under subsection C, if it's believed that the person does in fact need medical care, then the officers and employees are to provide emergency first aid if that is what's required, and then immediately secure additional medical care in accordance with subsection A, meaning the prevailing medical standards. The correctional facility is to have at least one person on staff at all times that is trained in emergency first aid. So somebody who's staffing 24/7 with that standard of training. And subsection D, DOC is to establish and maintain policies for the delivery of healthcare in accordance with subsection A, again, that prevailing medical standard. Subsection E. So except as otherwise provided, and then we'll see the exceptions below, an inmate that's admitted to a facility will under the care of a licensed physician, a physician assistant, an APRN, and who is taking medication at the time of admission to the correctional facility pursuant to a valid license, and that has been verified either by the inmate's pharmacy of record, their PCP, their primary care provider, their licensed care provider, or it's been verified by the Vermont prescription monitoring system or a similar prescription monitoring or information system. So it's been prescribed, it can be verified. And that medication may be buprenorphine, it may be methadone, but if they have a valid prescription upon entry, they're entitled to continue to receive that medication and to be provided that medication by DOC pending an evaluation by a physician, physician assistant, APRN, that they need that medication.
So I just want some clarity. So when a person's coming in, if they have a valid prescription that has been prescribed by by a licensed physician or physician assistant, that's someone in the community.
Mhm.
It's not someone within corrections. So they're entitled to continue that medication,
Mhm.
to be provided that medication by DOC pending an evaluation by licensed physician, PA, or are those last bit under DOC? Or are those licensed physician, licensed assistant, or registered nurse out in the community, or is that within the correctional facility?
The statute doesn't specify. So it could probably be either. But as the screening is occurring within a correctional facility, it would seem to me that probably it's happening in the facility and not out in the community, but the statute doesn't specify one way or the other if it's community-based or correctional-based provider.
I think the intent was that it's inside the facility because once someone becomes incarcerated, they don't have access to their provider out. But when we put this in place, we wanted to make sure if someone's got a prescription for any medication, whatever it is, and it is valid, and it is active as well at a local pharmacy, that prescription would be carried through once they're incarcerated. Michelle?
Yeah, so I have a question. I mean, on the letter A where it talks about prevailing medical standards,
There's a
sort of, well, no, more specifically though. So I would assume that that prevailing medical standards include if a doctor prescribes something that it should be followed through with. And like we had a situation here, we had a couple of people give testimony. For example, somebody with a cancer history had a doctor say, you should get a biopsy within 90 days. And it had been 11 and a half months and the person hadn't had the biopsy yet. So I would assume isn't part of prevailing what's the expression? Prevailing standard of care, medical standards. Wouldn't part of that be following through with prescribed medical advice from doctors that aren't in DOC when they do consult with them or not?
The definition of prevailing medical standard is not defined in statute. I did a statutory search. The only time it appears in the Vermont statutes annotated is the one time it's used in this statute. I looked at case law. There are 9 cases in Vermont that pulled up the language prevailing medical standard. None of them, the court doesn't go into how to interpret that phrase in any of them. They're all sort of dealt with on more technical or procedural basis.
So at this time, if a specialist says you should have a certain procedure and DOC decides not to offer it, they're not violating the prevailing medical standard.
I don't feel comfortable commenting on a particular situation. I would say in the absence
I'm talking in
of
general.
statute, a statutory definition, or in the absence of the court interpreting the phrase for us, we'd sort of use the plain meaning of the words. What does it mean? So the current standard of care would be what the prevailing medical standard is. So if the current standard of care in a particular field of medicine requires follow-up within a certain period of time, then possibly. It depends what the current standard of practice is, standard of care is for a particular field of medicine.
I mean, my understanding with a couple of the examples we had here were there was a specialist and then there was DOC. And so one person said, oh, you should have a diabetic pump installed. And then the DOC doctor said, no, you shouldn't. So who has the authority to decide what's the prevailing standard of care? I mean, it seems like in practice, it's been DOC.
They're under the custody of the state. And once they become under the custody of the state, it is our medical provider in DOC that has those determinations. Because the person loses. If they had a private provider, they lose that. And part of the reason they lose is because there isn't insurance coverage for that medical provider on the outside to serve folks on the inside. So it's our medical provider. Could be, if we had a state-run system, it would be a state employee. It could be a doctor, it could be an RN, whatever, that would be making those decisions. So in the situations where we had a couple of folks testifying, I think it would really be important, maybe for folks who are really interested, to do a little deeper dive and talk to DOC. Because there may be some other issues there that didn't come to light in a public testimony. So you might want to do a little deeper dive there. You might find that there's some other situation that has occurred. Doesn't mean it's right, or doesn't mean it's wrong, but there may be other things that at play that we're just not aware of.
I'd just like to know in terms of precedent, if something like cancer, you're not necessarily gonna have cancer when you come to DOC.
Right.
So you're gonna have to go to a specialist. So I would think the prevailing standard of care would include following the advice of the specialist, not just the person from DOC saying, oh, well, we don't think you need that. You know, I'm not talking about,
I agree with it, but I think that's why if there's a situation that comes up like that, it would be good to find out the other side to see if there is an error on the other side or see if there was a valid reason. We don't know. We don't know. We only heard the testimony and we didn't do a deeper dive. Some of those things are better if you just reach out and find out what the other side of the story is. But I'm not saying it's right. If there's an order to have a follow-up procedure in 90 days and that doesn't get acted on, there's an issue somewhere. And I'd like to know where that issue is before I jump to conclusions. That's all I'm saying. For that.
I second that because we heard one side of the story.
Right. For one side of the story every day.
Right.
You're taking over 100 and something hours of testimony from prisoners' rights in less than an hour of testimony from victim services. We are constantly hearing one side of the story. So I agree with that statement, Madam Chair. We need to do a better job of hearing both sides of the story and basing decisions upon appropriate responses, not emotional reactions.
So this
Thank you.
This is our role right now to see what's in statute currently, what may need to be addressed, what is working, and what may not be working for that. But we need to know what is in statute and is the law being followed.
Okay, so we had just talked about a person who is coming into a correctional facility with the medication and that they're being able to continue that medication. I mentioned there was an exception. So here is the exception. DOC may defer the provision of a validly prescribed medication if, in the clinical judgment of a licensed physician, PA, APRN, it is not medically necessary to continue medication at that time. And we do have a definition of medically necessary that I'll get to. So once the person is evaluated within the facility, there could be a determination that this medication is no longer medically necessary for this individual, in which case it can be discontinued. Subdivision 3 gives the process for the documentation that needs to be made to discontinue the medication. So when this licensed practitioner makes a clinical judgment to discontinue the medication, the practitioner is to cause the specific, shall cause the specific reason for the discontinuance to be entered into the inmate's medical record. A specific explanation of the discontinuance decision shall be provided to the inmate, both orally and in writing, with notice of the right to have the inmate's community-based prescriber notified. So the inmate themselves can choose if they want their community-based provider notified that the medication has been discontinued. If the inmate provides a signed authorization to do that notification, DOC shall go ahead and notify the community-based prescriber. Subdivision 4 stipulates that the GA does not intend to create a new or additional private right of action. And then the definition I had promised, medically necessary, is in subdivision 5. It describes, so medically necessary describes healthcare services that are appropriate in terms of type, amount, frequency, level, setting, and duration to the individual's diagnosis or condition, are informed by generally accepted medical and scientific evidence, are consistent with generally accepted practice parameters. Such services shall be informed by the unique needs of each individual and each presenting situation, and shall include a determination that a service is needed to achieve proper growth and development or to prevent the onset or worsening of a health condition. So I have that quoted specifically because I felt like the definition was important enough that you have the exact language in this handout. There's also a definition of medically assisted treatment. I think when the committee actually adopted this language, there's a lot of go around about what the definition should be. But the important piece on MAT will become important in future sections that we're going to look at. But that MAT is not just a medication. It's sort of a combination of receiving medication for an opioid treatment disorder in conjunction with other types of therapeutic treatment. And then in subsection F, any contract between DOC and a provider of physical or mental health services must establish policies and procedures for continuation of the provision of medication at the time of admission and afterwards, as determined by an evaluation that protects the health of inmates.
So Katie, the definition of medically necessary, is that just in DOC statutes or is that elsewhere?
This is specific to this chapter. And you'll see it a lot with regard to the MAT language that we're going to look at.
And MAT, is there a definition for MAT, the DOC statute?
No, it's cross-referenced.
It's cross-referenced to another,
Title 18.
where MAT is defined in statute is not in Title 28, it's in Title 18, and we refer to it. So the MAT definition pertains to folks out in the general community as well as folks who are incarcerated.
Trying to find, if you are interested, it's 18 VSA 4750.
4750?
Yeah. Okay. The next section pertains specifically to pregnant inmates. The first subsection gives Vermont's policy on pregnant inmates to respect the unique health issues associated with a pregnant inmate. DOC is not to restrain a pregnant inmate beyond the first trimester in the same manner as other inmates, because doing so may pose undue health risks to the mother and unborn child. The commissioner of DOC must ensure that all reasonable and appropriate measures consistent with public safety are made to transport a pregnant inmate in a manner that prevents physical and psychological trauma, respects privacy, and represents the least restrictive means necessary for the safety of the inmate, the staff, and the public. And then the last bullet, unless a pregnant inmate is a substantial flight risk or there are other extraordinary circumstances, mechanical restraints cannot be used once an inmate is declared in active labor. The inmate shall remain unrestrained after delivery while recovering at a hospital. And if there is an event in which mechanical restraints are used during labor or during recovery after labor, the commissioner has to make written findings as to the reasons why those restraints were necessary. And now we're moving on to a lengthy section on medication-assisted treatment, which is just had a thought. The terminology last session has migrated from MAT to medication for opioid use disorder, MOUD. I'm almost wondering if this cross-reference now to MAT would need to be updated to use that that new language. I'll have to check 4750 to see if it was changed there.
Confuse the issue.
I don't know.
What's the
I'm
new?
afraid.
What is the new MOUD?
MOUD, medication for opioid use disorder.
But I'm afraid that's going to confuse the topic and issue, what we're dealing with. I know we can reference it, but it's been known as MAT ever since we started it.
Let me double check 4750 and see if the terminology changed in that instance. If it did, then you're cross-referencing MAT to a definition that's MOUD in this definition section. So I will do my homework and I'll see if 4750
I'm
was
sorry to give you more
updated.
to do.
No, I'm happy to look.
We can look it up.
Change, the name change? Is it the same thing? Is it a synonym?
A synonym. My understanding is that the terminology in the field has continued to evolve, and that is the terminology that providers are using, and that's why the language in the substance use disorder bill that passed last year was updated. So I will take a look at that. We'll use MAT for the time being. So when subsection A, when an inmate is receiving MAT prior to entering the correctional facility, and they're continuing to receive medication prescribed in the course of MAT pursuant to the language we looked at in the previous section, the inmate is to be authorized to receive medication as long as medically necessary. So there's that use of medically necessary again. And subsection B, if the inmate ever screens positive as having an opioid use disorder, the inmate can choose to commence buprenorphine specific MAT if that is deemed medically necessary by a provider authorized to prescribe buprenorphine. The medication is to be available as soon as possible for as long as medically necessary. And then in subdivision B2, this section does not prohibit somebody who starts MAT while in a correctional facility to transfer from buprenorphine to methadone if methadone is deemed medically necessary by a provider who's authorized to prescribe methadone and the inmate chooses to commence methadone. In subsection C, the practitioner who decides to discontinue a medication is to cause the specific reason to be entered into the inmate's record. This tracks the language we looked at in the previous section. They have to have a specific explanation in the record as to why the medication is being discontinued. Notice has to be given to the inmate orally in writing. The inmate has the option to notify their community-based provider if the medication is being discontinued, and if that's so authorized, DOC can provide notice to the community-based prescriber. Subsection D deals with re-entry planning. So DOC has to commence MAT prior to an inmate's release from a correctional facility if the inmate screened positive for an opioid use disorder, MAT is deemed medically necessary, and the inmate chooses to commence MAT. And then in subdivision D2, if MAT is indicated, and despite the best efforts, induction is not possible prior to the person's release from a correctional facility, DOC is to ensure comprehensive care coordination with the community-based provider. In subsection E, counseling and behavioral therapies must be provided in conjunction with the use of medication for MAT. So that's what we were talking about before. When we say MAT, we don't just mean a medication. We mean there are therapeutic practices that go along with that. And so the health department's MAT rules cross-reference there as having to follow that process.
So Katie, I did look up section 4750.
Is it MOUD?
Yep.
Yeah, I thought so, okay. So, well, we can chat. But right now the cross-reference is not quite parallel. Okay, so we're moving along to a different subchapter. This is a subchapter about serious functional impairment designation. So like I did with the medically necessary definition, I've cut and paste this definition because I think it's important enough that you see all of the language. Ooh, I'm just seeing my quote marks are going the wrong direction. I'll fix it and send it back to you.
I think that could be.
Okay.
That's
Over, I don't think.
that's okay.
Oh, no, that one's okay. It's this one that's in the wrong direction.
Yeah.
So I think what's important to know about serious functional impairment is it's not a diagnosis. It's a correctional designation. So it's not, it could include somebody with a mental health condition. It's broad in how it's phrased, but it's not meant to be a diagnosis that somebody carries with them outside of a correctional facility. It's a manner of sort of categorizing and knowing what types of services to provide a person while they're in a correctional facility. And the legislative intent language in this subchapter says that GA intends that SFI designation applies solely to individuals residing in a correctional facility and not to individuals reentering the community after reincarceration. Then we have our definition of SFI. A disorder of thought, mood, perception, orientation, or memory as diagnosed by a qualified mental health professional, which substantially impairs judgment, behavior, capacity to recognize reality, or ability to meet the ordinary demands of life, and which substantially impairs the ability to function within a correctional setting, or a developmental disability, traumatic brain injury, or other organic brain disorder, or various forms of dementia or other neurological disorders, as diagnosed by a qualified mental health professional, which substantially impairs the ability to function in a correctional facility. So that phrase, I think, is important, the ability to function in a correctional facility. So this is a condition that somebody might have, and the importance is how they're able to function within that setting. Jumping to section 907. This requires the commissioner to administer a program for trauma-informed mental health services that are available to all inmates and to provide adequate staff support to the program. And then we go in to have a list of all of the following services that are provided under this trauma-informed mental health services that are provided. So each of these bullets is, an element of service. Within 24 hours of correctional facility admittance, all inmates must be screened for signs of mental illness, mental condition, psychiatric disability, or SFI. And if the result of screening is that the inmate is receiving services under the Developmental Disabilities Home and Community-Based Service Waiver, or is currently receiving community rehabilitation and community services, the inmate is designated as SFI. An inmate that's identified as the result of a screening by a mental health professional is requiring inpatient evaluation, treatment, or services is to receive such evaluation, treatment, or services in an appropriate clinical setting within 48 hours. Trauma-informed evaluation by a qualified mental health professional, including a review of available medical records for an inmate who has a history of a mental condition or psychiatric disability, has received community rehabilitation and treatment services, and shows signs and symptoms of a mental condition, psychiatric disability, or disorder of SFI at the initial screening or observed since they've been in the facility. Development and implementation of an individual treatment plan when there is a clinical diagnosis of a mental condition, psychiatric disability, or SFI. Access to a variety of services and levels of care consistent with the treatment plan to individuals with a clinical diagnosis, mental health condition, psychiatric disability, or SFI, including follow-up evaluations, crisis intervention, crisis beds, residential care within a correctional facility, clinical services provided within the general population, services in the designated special needs units, implementation of discharge planning with DMH or with DAIL, depending on the individual. It coordinates access to eligible services and consistent with re-entry case planning. Other services that either DAIL and DOC jointly or DMH and DOC jointly determine to be appropriate. Proactive procedures to identify inmates who have not received enhanced screening, evaluation, and access to mental health services. Special training for medical and correctional staff to enable them to identify and initially address inmates with mental conditions, psychiatric disability, or SFI, including recognizing the signs and symptoms of mental condition, psychiatric disability, or SFI, signs and symptoms of chemical dependence and withdrawal, recognition of adverse reactions to psychotropic medications, recognition to improvement in inmates' general condition, recognition of a developmental disability, recognition of a mental health emergency, instructions for contacting the appropriate professional and taking appropriate action, suicide potential and prevention, and precise instructions, procedures for mental health referrals, and any other training that's deemed appropriate. So that's all part of the mental health services that are to be provided. This last section in this subchapter is that the commissioner of DOC must ensure that notice of the services that are available to inmates and the manner in which those services are obtained has to be widely disseminated to staff and inmates.
So questions? Any questions? I just want to be clear that there's a lot of definitions in this subchapter. SFI is defined, which you pointed out. Qualified mental health professional is defined. Mental condition or psychiatric disability or disorder is defined. And screening is defined. So there's a deeper dive there for some of this, just so folks realize.
So it's okay.
Yeah.
Oh,
So we have Representative Chino, you're here for the healthcare committee, correct?
Yeah.
Okay, so question?
Can I ask,
Yeah.
in that capacity, earlier, reviewed a section of the statutes where it said that there's a designation that only applies while they're in the correctional setting.
yeah,
Can we go back to that quickly?
sure.
I
That's,
just didn't want to interrupt. I didn't know if I was allowed to ask questions.
Yeah, you're here for the healthcare committee.
Yeah.
so
I invited the rest of them too, but they didn't.
And I think here's their designate.
Yeah.
SFI, serious functional impairment. It relates, you'll read in the definition, it relates to how the person functions within a correctional facility. So whether their capacity to function within the correctional facility is impacted. And it's a designation, it's not meant to be a diagnosis that somebody would carry with them out to the community. And there's legislative intent language in the preceding section
Yeah.
that specifies that.
So I just want to make sure I'm understanding this, that Vermont state law creates a form of diagnosis that a mental health professional gives a person, but that diagnosis only describes their condition in the facility. Do you know if this matches the DSM-5, which it just, do people know what that is?
It's supposed to match. If you go further down, it's supposed to match.
So like this
Spent a
DSM-5,
lot of time on this.
I have to look at
Yeah.
the definition.
I can look it up
The other
too.
two definitions of how mental health condition and psychiatric. What is the exact phrase that is used? Mental illness and mental condition, psychiatric disability. I think those are also defined. So I'd want to look at those too before I
Yeah.
answer your
We
question.
spent a lot of time on this and made sure that those definitions track.
I think the question I have is like, does the DSM-5 talk about conditions that arise in specifically in correctional facilities? Or is that something that Vermont kind of created based on the DSM-5? I'm just curious about it because either it could mean that there's some kind of inequitable treatment people are receiving if they're getting if they're supposed to get something for a condition in one setting, but then they're discharged, but it's considered it's gone, but what if it's not?
So let me read the definition of mental condition or psychiatric disability or disorder. Means a condition that falls under any Axis 1 diagnostic categories or the following Axis 2 diagnostic categories as listed in the American Psychiatric Association's Diagnostic and Statistical Manual of Mental Disease, DSM-4-TR, 4th edition, text revision, as updated from time to time. So that's one. Borderline personality disorder, histrionic personality disorder, developmental disability, obsessive compulsive personality disorder, paranoid personality disorder, schizoid personality disorder, or schizotypal personality disorder. That's the definition that we have for this subchapter.
So just something for us to, if we as a body are gonna look at updating the statute, that we now use the DSM-5.
Well, it does say as updated from time to time, so
Right.
DSM-4 was updated to 5.
And there were some major
But
changes.
hang on, fire away, because there was what was the biggest major change between 4 and 5? How we look at access, how we look at the co-occurring and how things are designated now within the access.
We changed the diagnostic understanding of certain conditions, like schizophrenia is now viewed as a spectrum disorder, like it's on a spectrum. That it's more trauma informed. And there's some things that we wanted in the DSM-5 that we didn't get that might come in the next thing, like around complex trauma. So I just think where the intersection of our committees lie, like there might be some benefit to looking at the differences in that manual and in our understanding of mental health conditions and substance use disorders. And just making sure that we're keeping up with that in our practices and policy that, you know, that's.
So Katie, it does say here, under that definition, this is in section 906 definition. It does say DSMI 4 as updated from time to time. So that would imply that DSM 5 is now in place or not?
It would. That's sort of language that we would use when we know a document, there are multiple reiterations. That doesn't mean that you can't go in and update it if you're planning to update other statutes. So
But it's not saying we're linked in to DSMI 4
no, it's saying as updated.
as updated. So we are doing the DSMI 5.
I think the piece that might not be consistent though is that if other language in statute was based on that manual and that change, even though we say we're keeping up with it, there still might be, like, this other language might need to be reconsidered. Specifically, like the idea that we would like create it's a social construction of diagnosis. So we would construct this idea that a person only has something when they're in the facility, and the minute they like are discharged, it's gone. That's just that to me feels like out of sync with what people really experience. But I don't want to go on about it.
That's a very delicate situation. We dealt with this way back because we're trying to. There's different classification in the community. And we were asked by the DAs, the designated agencies, to really clarify between SFI and is it CRT? Is it the CRT?
Yeah,
Because there
CRT.
was a lot of confusion happening out in the community with this. So this happened about 10 years ago, to really 8 to 10 years ago, to really clarify that SFI is a designation within DOC in terms of how DOC functions and how it functions in a facility. So an example is if a person has been classified with SFI, they meet the qualifications that are out there. There's only a certain time, like they go into SEG, there's only a certain time they can be in SEG. And there's a different process and time frame for that appeal and for that review. So it's how that person is, I don't even want to say handled, but how corrections, person who's incarcerated and they have an SFI classification, there's different criteria there in working with the person because of that designation. Once that person is released, you're not looking at the operation of a correctional facility for that person or the operation of that correctional facility and for the safety of that person in the facility.
That makes sense.
That's the key.
Well,
It creates eligibility for all of these services in 907 too. So even if the person is not meeting the definition of having a mental condition or psychiatric disability or disorder, they're still eligible for trauma-informed mental health services if they're meeting the definition of SFI.
It makes sense, Chair, your explanation makes sense. I think like the concern I have ultimately is that if we see that there's evidence that correctional facilities can generate mental health conditions, like 30% or whatever, 30-something% of individuals incarcerated reporting that they develop suicidality in the facility. If it's not, if people aren't, even if they're getting treatment in the facility to make them safer, if we have inadvertently caused a mental health condition by incarcerating someone and then we release them, they might now actually need CRT services. Like they might need a higher level of care when they're discharged, but not get it if like the designation or the diagnosis is something that we believe only exists in the facility. So there's a disconnect there. I think it might be something that we want to think about as we think about reentry processes and how to make sure, and how services are integrated better into facilities, things like that.
It might be worth a conversation with you folks to have that with the mental health arena
Yeah,
and the designated agencies, because that's where the rub occurred.
yeah.
Okay, that's where the rub occurred. So it might be worth your committee to do a deeper dive on the mental health piece in the community and what their perception or what their discussions have been with DOC folks reentering, if there has been any. Tristan?
Thank you, Katie. back to the overall provision of healthcare, and I think speaking to what Representative Bosland was raising, what I'm gleaning, what I'm gleaning is that sort of we have statutory language around providing healthcare that meets prevailing medical standards. That is essentially, effectively, I'm gonna say intent language, not defining the standard. We're not putting in teeth. We're not putting in accountability. We're just saying this is what we're supposed to do. And then the department goes about doing it, working with contractors, providers. And what, when we as legislators hear from, whoever we're hearing from, stories, accounts, it can be hard to track those down. Sort of, you end up saying, well, did they follow some procedure? Did they follow the contract? There's, so I don't know if I have a question here, a comment, just kind of reflecting on what I'm seeing. It's an intent, and then we just carry it out, and there's not accountability. There's not standards.
I would be careful on calling it intent language though, because in our statutes, we're very clear when we're saying something is the intent of the General Assembly, or if we're saying, if we're suggesting that it's aspirational, and that this language is not drafted in that way.
It's not drafted as intent
As
language.
intent language.
It's drafted as law.
Yes.
So I think maybe I'm saying something less, what I'm saying is more, maybe less legally sound and more of a commentary, that it feels like in effect, it doesn't have a lot of teeth, or doesn't have a lot of standard to it. So to me, it feels so simple.
Well, I think a lot of this gets carried out within the directives and policies. That's the other layer to this.
Where the rubber meets the road is where we see what this means.
Is there directives?
There's another subchapter.
I know, and you're looking at the time. because it's really by 4:50.
And this 703, I don't work in Title 28 very often, so every time I look at it, I kind of come to it fresh. And when I read this, I thought, wow, that's interesting language, because it doesn't at all match language on commitment to the custody of the Commissioner of Mental Health that we use in Title 18. So I flagged that for you. In this first bullet, it says the transfer of a person under supervision of DMH shall occur in accordance with the commitment proceedings under Title 18, Part 8. So to me, this is saying, okay, if a person is in DOC custody and it's recognized that this person meets the statutory definition of needing to be in the care and custody of the Department of Mental Health, then a transfer can occur so that that person is in the custody and getting treatment in the Commissioner of Mental Health. But the word supervision is very strange to me, because normally we would recognize that it is somebody who is in the custody of DMH or committed to the custody of DMH. And I'm not really sure what that supervision is. I was so interested by this that I reached out to the General Counsel of DMH to see if she knew that this was there and what she interpreted it as, and she was also surprised to see the language. So I flagged that as something that you might want to look at a little bit more closely, to see how that matches with Title 18. So if a person is in fact transferred from DOC custody to DMH custody, what this cross-reference to Title 18, Part 8 signifies is that there's usually a court process to commit somebody into the custody of the Commissioner of Mental Health. It means a person meets the statutory definition of a person in need of treatment. Very generally speaking, that means they're a danger to themselves or others. The definition is much longer. And then there's usually a length of time that the person is committed to the custody of the Commissioner of Mental Health. There are different types of treatment that the person can receive, and that is stipulated by the court. And then if the person continues to need treatment, when their initial order is about to expire, the Commissioner of DMH can apply for a longer period of treatment. So if that person is transferred to the custody of DMH through a court process, any time that's spent in DMH's custody is to be computed as part of the term for which the person was sentenced. and the person shall continue to be eligible for good behavior reductions and eligible for parole during that time. And then the next section has to do with when the person is no longer needs to be in the custody of the Commissioner of Mental Health. So when the custody of the commission, when the Commissioner of Mental Health determines that the person whose sentence has not expired, so they still have time on their sentence, they no longer meet that statutory definition of a person in need of treatment or a person in need of continued treatment, then the person is to be returned to the custody of the Commissioner of DOC to finish their sentence. And 705 deals with, well, what happens? The person is in the custody of the Commissioner of Mental Health and their sentence expires. So under this language, if the Commissioner of Mental Health determines that the person transferred to the Commissioner's custody needs further care after the expiration of the person's maximum sentence, the Commissioner is to petition the Criminal Division of the Superior Court for recommitment of the person into DMH's custody. The petition shall be filed prior to the expiration of that maximum sentence. And the Criminal Division there is, I don't know if I want to say significant, but most of the proceedings for commitment to the Commissioner of Mental Health are in the Family Division. So this is specifically saying, yeah, but if the person's sentence is about to be expired, then this commitment has to go through the Criminal Division.
So this word supervision is under Title 28, so we could change that word.
You might want to hear from
I want to hear.
DMH, yeah. It struck me as an interesting choice, in that it is not the choice or the language that's used in Title 18 to talk about custody and commitment, which led me to wonder, does this mean something different altogether?
There's an MOU between DMH and DOC about folks with mental health issues while they're incarcerated. There is an MOU. I do have a copy of it somewhere. And also, when they're transferred to the state hospital from a correctional facility, what the testimony we've heard over the years, they're transferred there so that to provide stabilities. And once they become stable, they're brought back to the correctional facility. So sometimes it's a stay of a few days or a few weeks or whatever. I'm not sure, I'm trying to remember, are they totally out from under the custody of the Commissioner of Corrections? When they're at the state hospital, are they fully under the custody of the Commissioner of Mental Health? When they're at the state hospital? Or is there dual custody, and that's why the
Interesting.
word is supervision?
That's interesting. I'm not sure.
I'm not sure either.
It's 4:30.
Hmm?
It's 4:30.
No.
Because the custody could only come through a court process,
Hmm.
perhaps not.
But this does cross-reference the proceedings in Title 18, Part 8, which is a court process. So it is referring to commitment through the court process. Yeah.
So we'll schedule some testimony to hear from DMH and DOC on this to go into. Questions? Does this help the committee or does it make it more confusing?
Clarify.
And then we can take some testimony on this as we do it. Thank you so much, Katie.
You're welcome. It was nice to see everybody.
We hope we didn't make.
Okay. Oh, you didn't need me with it.
You're only 30 seconds late.
Perfect. Thank you.
So we're done for the day, folks. Very anxious to get out of here. We'll schedule some time with DMH and DOC. And Brian, maybe you could report back to your committee about doing that deeper dive from DMH for folks that are reentering with mental health issues, how that dovetails with SFI or doesn't. So we're done for the day.